Mr Chairman, I heard the Minister minimise the reality of this part by saying it follows from a part which we have been debating at some length. I don't think that that is a fair and reasonable response from the Minister. In fact, it sounded as if she was trying to put off having to respond to the questions that have been put to her, and actually to try and encourage the Chair perhaps to close down the debate on what is a significant other part of the bill. And nobody can actually ignore the fact that this has major consequences for our children. And I still cannot hear the Minister use that word children. And the reason she can't use that word children is because she finds it really, really difficult to accept the fact that that is what the law says. That is the law she is responsible for administering. And what she is responsible for administering is ensuring that our children are protected, and she has obligations under the United Nations Convention on the Rights of the Child, and she is completely ignoring them. That Minister has not responded to a single question that I asked the last time that we were debating this issue, that Jacinda Ardern asked earlier, Rajen Prasad, and now Moana Maki. All of us has asked a series of questions around the implications for New Zealand's standing in front of the United Nations. And the Minister of Justice is in the room, and he's been in front of the United Nations and responding on our human rights standing. This bill wasn't even mentioned, even though it was before the House, when that Minister appeared in front of the UN. No, it wasn't even mentioned, and yet it was still in front of the House at the time. I want to know what the Minister's advice has been from her officials about what New Zealand's standing is going to be with the United Nations when this bill is passed into law. And I think that she has had advice that this is a breach of the United Nations Convention on the Rights of the Child. It seriously challenges it, not only in Part 1, but especially in Part 2, when we are dealing with compulsory DNA testing. And I think that the Minister should actually respond to that question. I've had feedback on this debate. I don't often get people walking up to me at functions and saying to me, you gave a... No, they come up to me at functions, but they don't often, generally speaking, they don't often come up to me and say, I thought you gave a really good speech in Parliament this week. And I said, I was surprised. I keep forgetting that we've got Parliament TV now, and people channel hop, and every now and again they stop when they see something interesting. And this guy said to me, he said, and because I said to him, which speech was it? Because I'd given quite a few last week. And he said it was about children and who was responsible for children. And I talked about the rights of the child to be protected from a whole lot of adverse effects, but that responsibility lying with their parents, lying with their family, and also lying with their wider community. And I think it was in response to some ridiculous comments that we'd had from the ACT Party member, David Garrett, who had been particularly repulsive with respect to his comments about how these weren't children anymore because of the acts that they had committed, not prepared to look at the circumstances, the deprivation and indeed the damage that had been done to these children within the environments within which they'd grown up. But never mind that, he didn't seem to care about this. What this person, who actually fortunately turned out to be a constituent, a long way away from the electorate, but I was very pleased to find out that my constituent thought that I had given a good speech. He said that while I was talking, he started thinking about his son. His son was 11 and a half years old, and he suddenly realised that what Parliament was debating was the criminal age being lowered to an age where his son would be in 6 months' time, a child. Criminal responsibility given to a child for offences other than murder and manslaughter. Because, again, I think people dwell on the murder and manslaughter. The law already allows for the criminal responsibility to sit at the level that it does for murder and manslaughter. And the other question that he raised with me, and which the Minister did not respond to, was this question of who murdered Michael Choi. And the whole public, Mr Chairman, Mr. Chairman,
The Honourable Leanne Dizzer.
the whole public, the general public, seems to believe that the person who took Michael Choi's life was an individual called Bailey Jr. Kurariki. But Bailey Jr. Kurariki was found guilty of manslaughter along with Philip Kokazi, Ricky Rapira and Joe Kokazi. Those that actually took his life were Alexander Tokarua Paihopa and Whatarangi Rawiri. Nobody in this House has ever heard of these other people. Why was Bailey Jr. Kurariki held up to the public as the face of the youngest killer that this country has ever had? It was because of his age. And what the Minister wants to do is to open up to that kind of pressure every other 11 and 12-year-old that falls off the track and ends up, a 12 and 13-year-old that ends up in that situation in a wider range of offences. No one is justifying what these children do. No one justifies the fact that Bailey Jr. Kurariki, in conjunction with his friends, who, I have to say, they were older than him, and he possibly was led astray. He was 12 years old when this happened. He rang the pizza place, and that was why the pizza was delivered to that house, and he opened the door when the pizza arrived. But he has become this country's entire focus on this individual who killed Michael Choi. It was not Bailey Jr. Kurariki who did not, it was not him who killed Michael Choi, but he was involved. And I think that what the Minister has completely lost sight of is that in Part 2 we've got the situation where the DNA testing becomes part of the total package that follows that young person through the rest of their life. And so in this case of Bailey Jr. Kurariki, he will not only have that following him for the rest of his life, he had the outcome of the media essentially finding him, judge and jury as they are, finding him guilty of the most heinous offence that one could imagine with respect to what occurred. So I think that the Minister has not taken responsibility for ensuring that New Zealand is able to maintain its status with respect to the UN Convention on the Rights of the Child. And what is so amazing is that the Minister of Justice has moved an amendment in a bill that he introduced only a week ago to allow for a change to our adoption laws so that in fact we can we can actually sign up to one of the convention provisions that we have not been able to sign up to up until now. And I think that the Minister does New Zealand a great disservice, one, by ignoring the fact that we are talking about children, second, by actually minimising what is the issue with respect to DNA testing. And the Minister can play on her BlackBerry as much as she likes, but it's not really fair that she's not participating in the debate. She's simply just, playing on her BlackBerry as she sits there at the front. I would have thought that was probably out of order, but there you go. She's not prepared to participate in the debate in a reasonable way, and she's missing the ultimate point, which is she has an obligation to ensure that New Zealand is always able to provide for its obligations under the UN Convention on the Rights of the Child. Other ministers stand in front of the United Nations talking about our commitment to human rights, and yet on this particular issue, this minister is prepared to stand back and say it's okay that children are able to be tested in the youth court, held to account in the youth court for their actions, never mind all of the reasons that might have brought them to the fact, never mind the damage that has occurred from their upbringing, never mind the lack of support that they've had from their family and their community. These are children, and Part 2 is just as important as Part 1, and this side will continue to debate the importance of Part 2 until the Minister actually takes on some responsibility and gets up and explains why she thinks it's okay that mandatory DNA testing is applicable to 12 and 13-year-olds, children under the legislation that she is obliged to oversee.